So I'm often asked, what's the difference between a will and a trust, and do I need both? A will is a legal document that tells a court how you want your assets to be distributed after your death. If you have assets over a certain amount, it requires the executor to go into court and get an order from the court to distribute your assets using a process called probate. Probate can take quite a long time here in California, and it's typically quite expensive. The worst part is it's totally public, and it's subject to the oversight of a broken-down court system. Plus, a will is only operative in the event of your death and not your incapacity. So your loved ones could have difficulty getting access to your assets in the event that you were in the hospital and could not communicate. A trust is a legal document that tells a trustee, chosen by you as the creator of the trust, how you want your assets to be handled if you're incapacitated or in the event of your death. So long as your assets are owned properly by the trust, it does not need to be brought before the court, so it's totally private. And the person you choose as the trustee has total control over the process, which is a lot less expensive and much quicker than the court process we call probate, which was required when all you have is a will. Typically, you need to have both, because a trust only works if your assets are owned in the name of your trust, and sometimes an overlooked asset gets left out, and it will be subject to the will.